a quick road so far with the University of Idaho murders and the prosecution of Bryan Kohberger. We are getting ready for a court hearing today regarding two motions. The prosecution made a motion to, quote, an order prohibiting contact with prospective jurors absent leave of the court. And then the defense made a motion to rescind a court order for failure to provide due process. So there are two things on the docket today that are interconnected. The prosecution made a motion for an order prohibiting contact with prospective jurors because they say that the defense was surveying potential jurors in Latah County where this court sits. They were doing that via telephonic survey through a survey company with the use of an expert who was helping craft that survey. The defense says, yes, of course we were doing this. This is perfectly allowed. I don't know why everyone has a problem with this, because this is how we are going to find the evidence to support the motion for change of venue. Generally, motions for change of venue happen while jury selection, or at least the process of gathering a veneer, is underway. When that happens, the court sends out the juror survey from the court. And those surveys are made in connection with both the prosecution and the defense, and they ask open-ended questions. So it seems that the court and the prosecution, from both the defense motion and the prosecution's motion, that they were not aware that this is the process the defense was going to take. Now, can the defense do this in Idaho without permission of the court? We'll see what Judge has to say. The prosecution and defense in all of their motions have been silent as to whether or not this is proper process without court permission. And the prosecution is arguing that it violates the non-dissemination order. The prosecution is not saying that it violates any other court rule or law in Idaho. They've said very specifically that it violates the non-dissemination order, which indicates to me that perhaps without the non-dissemination order, this is something that could be done by the defense without leave for permission from the court. Because if that wasn't the case, you would expect the prosecution to say, this also violates rule of court, whatever, local rule, whatever. And we haven't seen that in any of the filings. But there's also been no discussion about the survey process, and that is very interesting to see. So we will see what Judge decides to do. But what we know is that the prosecution filed their motion for order prohibiting contact. The same day, the defense said, stop, collaborate, and listen. We object to the prosecution's issue, and we will be filing more information down the road. After that happened, the court said, no, you stop right there. Thank you very much. No one's going to be talking to jurors until we have a hearing on this. The defense then made a motion saying, excuse me, no, stop in the name of love. You're at least in the name of due process. What you can't do is issue an order without hearing from the defendant. And you didn't hear from the defendant yet. So you can't make the order stopping us from doing surveys without hearing from the defendant. The prosecution said, well, we're going to set a hearing. So if we're going to set a hearing, the defendant will be heard from. So this is fine. It's happening. Oh, we get to hear the questions. Oh, we get to hear the questions.
Question. Have you read, seen, or heard if Bryan Kohberger was arrested at his parents' home in Pennsylvania? Question. Have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question. Have you read, seen, or heard that DNA found on the knife sheath was later matched to Bryan Kohberger? Question. Have you read, seen, or heard if Bryan Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred?
Oh.
Have you seen, read, seen, or heard if the cell phone tower data showed that Bryan Kohberger made several trips near the victim's home in the month before the killing?
Oh.
Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Bryan Kohberger was arrested for the murders?
Oh boy.
Have you read, seen, or heard if Bryan Kohberger said, that he was out driving alone on the night of the murders? Have you read, seen, or heard if Bryan Kohberger stalked one of the victims?
Oh, God.
Have you read, seen, or heard if Bryan Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial.
Oh, boy.
Or the performance results of examination tests. And these questions specifically refer to DNA testing.
The problem with these questions is they are very specifically related to things that may be evidence in the case, and that is what is in the non-dissemination order. After a hearing of about an hour and 20 minutes, the court has set another date to figure out how to reformulate the survey, and if that is possible, to talk to the defense's expert and figure out if any of the survey can be salvaged, because it's clear that the court has issues with the questions that were asked. And the prosecutor read those questions into the record, and they were very pointed, including, have you heard that Bryan Kohberger stalked one of the victims? Have you heard that Bryan Kohberger followed one of the victims on social media? Have you heard that Bryan Kohberger's DNA was on a knife sheath? And others. The court also took up the issue of whether he violated the due process rights of the defendant by not giving them an opportunity to be heard before he made the temporary order to pause the survey. The court found that he did not. The prosecution also strongly argued he did not. And Taylor, for the most part, argued with the court and then let it go because the court is not withdrawing that order. The survey that the defense was conducting in Latah County was complete. The survey as to other counties has not proceeded. Interestingly, what we learned is that Ann Taylor says that she did not review the questions that were being sent out, but knew that potential jurors would be surveyed to show if a change of venue motion is necessary. The prosecution said very clearly, we knew that a survey was anticipated or would be needed at some point, but we did not know that these particular questions, which go to specific information and in some cases false information, would be directly and specifically asked of potential jurors. And the prosecution said, we might need a new survey if you're going to survey multiple jurisdictions. And we might need the information of the 400 people that were already surveyed so that they can be excluded from the jury roll if this trial stays in Latah County. The prosecution was noticeably frustrated when arguing about this. The judge, and Judge is normally fairly affable and calm and enjoys these attorneys. Judge was very frustrated with the accusation that he had somehow violated the defendant's due process rights by exercising his emergency powers to pause what was happening for a matter of 2 weeks when there is plenty of time for this motion for change of venue to be heard and a trial date that's not even been set and is anticipated sometime in the summer of 2025. The judge was deeply offended by that insinuation and made that very clear to the defense attorney, Ann Taylor. It will be interesting to see where we get from here. This court will be back in session on April 10th at 4 p.m. Pacific Standard Time. I'll be covering that. The judge wants to question the defense's expert to see if there's anything salvageable in this survey or if they need to scrap it, do a new survey in Latah County, and then survey the surrounding counties, including something in the more southern area of Idaho, and then, of course, the county where Boise sits. So we will see what the judge does next week. We will have more formal rulings on the record probably tomorrow or the next day, lining out everything we just talked about. But the judge denied essentially, or will be denying, the defense's motion to withdraw the court's order for lack of due process. And the court will take up the issue of what questions should be on that survey next week. So for now, the temporary order that I covered on Tuesday stands. And as it is, there is no surveying or should not be any surveying happening until the court rescinds that order, likely after the hearing on April 10th. And with all of that, Law Nerds, cheers. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.